We're joined now, though, on Zoom by former Suffolk County Sheriff, former Massachusetts Secretary of Public Safety, and noted Sue O'Connell impersonator. And the reason we say that is while we are thrilled to have Andrea back with us, Sue was supposed to be here, but she's got to be in the courtroom for the Karen Reed thing. So we were very lucky to be able to get Andrea. Hi, Andrea Cabral.
Hi, Jim Brady. Hi, Marjorie Egan, second time this week.
Yes,
Hello.
indeed.
Yeah, thank you very much, Andrea. So, Andrea, let's start with the Supreme Court. We learned today, some of us were hoping we'd hear about the former President Trump's immunity decision, but we didn't get that. But we did get the Supreme Court striking down this ban on bump stocks. People may remember that the shooter in that Las Vegas massacre where 58 people died was using a bump stock which enabled him to shoot more people more quickly and kill more people more quickly. So what do you think about what the Supreme Court did?
The shooter in Las Vegas had something like 18 rifles. Among the arsenal that he had included 18 rifles, most of which were equipped with bump stocks, which enabled him to get off between 400 and 800 rounds per minute. The issue in this case was whether or not a bump stock, when you attach it to a semi-automatic rifle, basically turns it into a machine gun. Any reasonable interpretation says that it does. And basically, Clarence Thomas, who sat silent on the Supreme Court for I don't know how many decades, never would even ask a question, suddenly has become very talkative. He wrote the majority opinion for this and basically tortured all logic to come up with an interpretation of what constitutes the human act of pulling the trigger. If people really want to see the absolute absurdity of this decision, read Justice Sotomayor's dissent. I think she starts out with, if I see a bird and it walks like a duck and it quacks like a duck and it behaves like a duck, it eats like a duck, I'm going to call it a duck. Her dissent is just a marvel of logic, common sense. It's everything sort of that a Supreme Court justice's opinion should have been in the majority. But what she says about Thomas and his opinion is, she says, a bump stock equipped semi-automatic rifle is a machine gun because one, with a single pull of the trigger, a shooter can fire continuous shots without any human input beyond maintaining forward pressure. She basically says Thomas looks to the internal mechanism that initiates fire rather than the human act of the shooter's initial pull. And that is what the law is about, human action. To hold that a single function of the trigger means a reset of the trigger mechanism. The majority's interpretation required 6 diagrams and an animation to decipher the meaning of the statutory text. That's how much they had to torture this so that Thomas could say that somehow this ability to fire between 400 and 800 rounds per minute doesn't require a human act. That's how insane this is. And we just it wasn't a celebration, but we just acknowledged yet another anniversary of the school shooting. I think it was the Parkland school shooting. I might be wrong on the exact one. There have been so many. And nothing has changed. And the Supreme Court has no intention of making it any more difficult to kill hundreds of people than it has been in the past.
One of the things, by the way, 58 people killed, which is just an unimaginable number. But one of the things CNN has done very well is they've stayed in touch with some of I think the number of injured may have been as high as 500.
Oh, yes.
And it's obviously, it goes without saying, when you lose someone you love, it's got to be unimaginable. But what people who were injured, only because this guy was able to do what you just described, what their lives are like because of the permission, essentially, for the American people to own anything they want, in my opinion, in clear violation of the Constitution, but obviously not in the position of Thomas and his friends, is unimaginable. This other thing we'd like to tell you is about the local aspect. The stories this morning mentioned that I think it's 18 states, Andrea, that where bump stocks will continue to be illegal because state legislation made that so. That Massachusetts is one. I was not aware of what the situation was in New Hampshire. Listen to this. Chris Sununu, the outgoing governor in New Hampshire, signed a bill barring state and local law enforcement from enforcing federal firearms statutes and rules. This is in 2022. So the New Hampshire statute prevents the state police and local law enforcement from cooperating with the FBI, the Bureau of Alcohol, Tobacco, and Firearms to do any investigations into federal firearm rules, such as the ban on bump stocks. I mean, to say this is performative BS that endangers the people of New Hampshire and anybody who travels through is an understatement. And do you really believe a person who's as smart as Chris Sununu did this for any other reason than to play to the people, the Trump people who he's always criticizing until he endorsed them? It's just grotesque in my opinion.
No, and I don't think that there's ever been a more prominent time in history where ignoring public safety for either reasons pertaining to money and campaign contributions or ideology, it became so obvious that it genuinely does not matter to any of these GOP types how many people die, how many parents lose their kids, how many kids lose their pets. They genuinely don't care. And the only response to this that will actually work is voting them out, as difficult as their gerrymandering has made it. But that's what needs to happen. We will not survive another presidential election if 40% of people choose not to vote, as they did in the election between Hillary Clinton and Donald Trump. We won't survive that because their intention is to a minority rule, an authoritarian minority rule, where public safety, whether it's environmental, it's in terms of guns or anything else, just doesn't matter.
Talking to Andrea Cabral.
So Karen Reed is a woman accused of running over her boyfriend, John O'Keefe, a Boston police officer, and leading him in the snow to die. The trial's going on over in Dedham. It's been televised as well. Yesterday we talked about the fact that the lead investigator in that case said horrible things about the defendant, calling her the C word, making fun of her Crohn's disease, which is kind of a tragic disease and very difficult for lots of people, said she should kill herself, went on and on and on. And I was saying that I thought the state police or Governor Healy or somebody should talk about this. Well, actually, Governor Healy was asked about it. I want to play a little sound of the governor talking about state police trooper Michael Proctor's text about Karen Reed.
It's terrible. I think anybody looks at that. I mean, it's completely unprofessional. It does harm, frankly, to the dignity and the integrity of the work of men and women across the state police and law enforcement. So as a former attorney general and as governor, I am disgusted by that.
I know you and Jim, the two lawyers, thought that nobody should be talking about this while the trial was going on, but I'm glad she said something, Andrea. I really am.
Yes, and I mean, but I agree. She apparently agreed with you, and I, as an individual, agreed with you, but as a lawyer and as you know, someone who's always very mindful of the impact that a public statement by an elected official can have, I felt that discretion was the better part of valor. Now comes the issue of not just all of the other cases that Proctor is on, the Brian Walsh case being one of them, and what might be in text messages, if he sent any, or other communications around that case. But the issue of the obligation of the Commonwealth to turn over information that may show bias on the part of investigators. You know, there's a two-part test. It has to show bias, but it also has to be, you know, relevant to the proceedings. But I think, as I said yesterday, that the door is now opening ever wider, that, you know, prosecutors are going to have to start asking questions when the issue is raised by the defense.
You know, by the way, there's a sort of, I guess, a breaking news thing out of the trial that is obviously going on, as Marjorie said, as we speak, Karen Reed trial. Court proceedings were halted by Judge Canone soon after getting underway Friday morning. Where am I reading from, Jamie? NBC 10, which is where Sue works. Before any testimony occurred, a sidebar was called, and the juror joined the sidebar. The judge was seen having a discussion with the juror. When the sidebar ended, the judge said the cameras must be shut off for the rest of the morning. The court went into recess around 9:20. Sue, who's in the courtroom, Sue O'Connell from NBC 10, Boston, said apparently the pool camera was on a wide shot when the court officers escorted the juror into the courtroom, so the juror was shown on camera, which I assume everybody knows is a no-no. That juror has been excused, so I assume one of the alternates is taking that juror's place. In any case.
Yeah, that is one of the dangers of cameras in the courtroom.
But it happens incredibly rarely, I should say, so hopefully that's not going to turn those who support transparency in the courtroom through cameras against them. We're talking
No, but I think the reason she did it is she really wants to strongly send the message that cameras, she's probably for cameras in the courtroom, but when she says no juror shall be photographed, the burden is on the people providing the camera to ensure that that doesn't happen, and I think she wants them to know she's very serious about that.
I would agree.
So, Andrea, first of all, I hate the word revenge porn. I don't know why people necessarily call this pornography. Basically, it's when someone takes a sexually provocative picture, a naked picture, semi-naked picture of someone, and then sends it out for other people to see. But we have finally done something about this in the Commonwealth of Massachusetts. What's up?
It is very rare that Massachusetts is like the 49th state to do something.
No, it's not.
That's very obvious. Well, with respect to most things, I know not everything, but we're usually not at the bottom. And this has been inexplicable to me for a very long period of time as to why this took so long. There's no argument against it. I mean, there are quibbles around, whether maybe the length of the penalty or something like that, but the basics are there, and I just don't understand why it took them so long to finally get this done, especially since doing this kind of thing has been growing in popularity over the years. So there's been a commensurate rise with what should have been a crime, and then a commensurate disinterest by the Commonwealth in doing something up till now. So credit to the legislators who really pushed this.
By the way, when Governor Healy signs this, which she says she wants to obviously look at the details, but she will the only state in America that will not have such a statute is South Carolina. And, as somebody who used to lobby, and I use the term loosely for a living, both at Congress and here, on something where there is no other side except language issues, Andrea Cabral, and is so important to so many people's safety and health. It seems to me when you have a disagreement over language, you stay in damn session until you work out the differences. Charlie Baker, to his credit, practically every month he was with us, worked this into the conversation.
Well, he talked to people that had been victimized by this and how people, it almost ruined their lives because they were so humiliated, really.
But I want to say again, if you called your legislator about this, and I hope a lot of you did, and they said, well, we're ironing out differences, as Andrea said, there were no differences on the merits. It may have been the language. And so if they weren't so hell-bent on this, I make a joke about it all the time, they're 5 months vacation and this other crap, and we're concerned about doing the bidding of people who need protection in the society, we wouldn't have been 49. So whether it's rare or not, it's totally unacceptable. And while it's great that they finally did it, it should have happened years ago. So, I mean, it's really, when you were the Secretary of Public Safety, were you not ready to, have a stroke over how slow so much, even if we're not 49th, how slowly so many things that there's no argument against take to make its way to the governor's desk, Andrea Cabral?
Yes. I mean, I can't tell you the number of times that we in this Commonwealth will set up a brand new task force or something that we've been arguing about in the legislature for a very long time, and so they punt it to a task force. Meanwhile, there's some room, I'm sure, in the Capitol that is filled to the brim with reports from previous task forces that have looked at the exact same issue. They never sort of dust those off. They always say when the issue gets renewed and they're still not ready to move on it, they'll create a task force. It's just, I don't know, it's inexplicable. And we know because on other things, they have moved with all deliberate speed, depending on, what it is, what the amount of pushback, political pushback is to it. We know they're capable of it, and this is just one of those examples that's particularly egregious, where they waited to be the 49th state to do something that was obvious to the first state that did it.
Amen.
So there's a terrible tragedy afoot involving Joey Chestnut and Nathan's hot dog eating contest that takes place every July 4th. Chestnut is a 16-time champion, but he has been ruled ineligible to compete. How could this be, Andrea?
Well, apparently he signed a contract with a rival hot dog brand that is actually a plant-based, I think, hot dog, which begs the question to me is whether or not that actually constitutes a hot dog.
You are so right, my friend. Go ahead.
They consider it a breach of his contract, but I'd say, if it's not a hot dog, then maybe he's not in breach, but that's a separate issue. But he signed a contract which, they say is a breach of his agreement with them to be representing this rival hot dog brand, but he is going to be able to have a special that's going to be streamed live on Netflix.
That's right.
With his chief nemesis in this, Takeru Kobayashi. And they're going to do a hot dog eating contest, I guess. I don't know whether it's a plant-based hot dog or a meat-based hot dog, but apparently it's going to stream live on Netflix, and he's going to be allowed to do that.
How many people here have watched the hot dog contest on July 4th? One insane soul.
Okay.
Three insane souls. It is the grossest thing
During
in the history of the world.
Storied career at the Boston Herald.
Oh, the sausages.
Somehow I wound up covering in East Boston the disgusting hot dog, sausage, pizza, whatever was going to be contest every July 4th. And it'd be 90 degrees and it'd be really hot and sweaty, and these people are shoving this, and they wet the hot dog buns so they can shove them down. Nice. Oh my God. It is the most disgusting thing. Why would anybody want to watch this thing if they didn't get assigned to it as a reporter to go over there and get nauseous watching it? I don't know.
76 hot dogs in 10 minutes is the world record set by Joey Chestnut. 76 hot dogs and rolls in 10 minutes.
Yeah.
Well, that's the other issue, is whether or not this plant-based hot dog, if they're going to use that, or if he's going to use it in this contest, has the same weight as, in a hot dog eating contest, it's about volume, right?
That's right.
Plant-based hot dog, is it lighter? Yep. Is he going to have an advantage if he uses the brand that he now
Why don't you investigate that, Andrea, and get back to us, okay? Okay, good. Thank you. Good. It's a pleasure to talk to you anytime soon.
Hey, Andrea, thank you very much.
Thank you,
See you next
Andrea.
week, Andrea.
Take care.